In Graham versus Connor, you have a Charlotte police officer. An officer by the name of Connor in the Charlotte Police Department was on routine patrol. He happens to observe a car pull up at a convenience store. In this car were two individuals, a driver and the passenger. The passenger was Graham. Graham was in the process of having a diabetic reaction. He needed sugar. He had his friend drive him to a convenience store where Graham got out. Graham went into the store intending to buy a bottle of orange juice to help him with his diabetic condition. When he got into the store, he was antsy. He wanted to get the orange juice as quickly as possible. He saw an extraordinarily long line in the convenience store and simply could not wait. He immediately ran back out of the store and into his friend's vehicle. Officer Connor, observing this behavior, thought something was suspicious, knew that something wasn't right, but he just did not know what. Officer Connor followed this vehicle. He followed it for a few blocks. He subsequently initiated a traffic stop to investigate exactly what was going on. When he pulled the car over, Mr. Graham is still agitated. He's still in the process of having this diabetic reaction. It was testified that Graham got out of the car after the traffic stop, ran around the car twice, went over, sat on the curb, and subsequently lost consciousness. Not knowing exactly what was transpiring, Officer Connor called for backup. Several other Charlotte police officers arrived on the scene. Several things were said and done during the course of that investigatory stop. One of the things transpired is that one of the officers on the scene commented that I've seen diabetics before and never seen one act this way. Another officer was heard to comment that he's just drunk, let him sleep it off. Subsequently, several of these officers physically picked up Graham, placed him and slammed him onto the hood of the patrol car. He was forcibly handcuffed. In the course of this encounter, Graham suffered a broken foot, an injured shoulder, and numerous cuts and bruises. During the course of this investigatory stop, word was subsequently received from other officers that in fact nothing illegal had transpired at the convenience store. Once getting this information, Graham was again picked up by the officers, placed in a patrol car, driven back to his home, and released. Because of the injuries that he sustained, Graham brought a civil rights lawsuit against the officers, alleging that excessive force was used in that particular encounter.
The thing that is interesting to me from the onset of this is that any reasonable officer would have thought exactly what the initial officer thought when he saw this car pull into the parking lot of a convenience store at a high rate of speed, a person jump out, run inside the store, then run back out of the store, jump in the car, and the car take off again. Was the officer's belief initially reasonable that something had occurred inside the store that was illegal? And I contend that it was.
This matter went up to the United States Supreme Court on exactly what standard should be utilized by officers in the course of those stops.
Maybe when 3 more officers arrived on scene, this person ran around the vehicle 2 times and then passed out on the sidewalk. Maybe a little more investigation could have been done at the time to see if they were involved in illegal activity or if this person was actually going through the dynamics of diabetic coma or diabetic seizure.
First decision that was made by the United States Supreme Court was to reinforce what was stated in Tennessee versus Garner, that what transpired in this particular circumstance was in fact a seizure. It was a seizure under the Fourth Amendment of the United States Constitution. And the second question was, knowing that some force was used to make this seizure, to stop Graham, the question then becomes what analysis should be used by the courts to determine whether or not there was an appropriate level of force used. That's significant. It's significant because the courts want to look at what the officer knew. What was he reacting to? What facts were presented to him? In point of fact, the court went on to state that all facts and circumstances of that seizure should be taken into account. They should include the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. General Statute 15A-401, paragraph D, specifically D1, Delta 1, talks about an officer's use of non-deadly force. Under North Carolina law, an officer is justified in using force, non-deadly force, when the officer reasonably believes that that level of force is necessary to 1, prevent the escape from custody of an individual, or 2, to effectuate the arrest of an individual, 3, to defend themselves, or 4, to defend another from what reasonably appears to be the use or imminent use of force. We know when you can use non-deadly force. North Carolina law also addresses specifically when you're authorized to use deadly physical force. Again, General Statute 15A-401, paragraph D2, speaks directly to when an officer can use deadly physical force. If deadly force is or appears to be reasonably necessary to defend the officer or a third person from what they see to be the use or imminent use of deadly physical force. North Carolina goes on to provide that other areas also justify the use of deadly physical force. If an officer has a reasonable belief that imminent threat of death is present or physical injury by that particular suspect, then deadly force could be authorized. Additionally, if that suspect is attempting to escape from custody that's imposed on him as a result of a conviction for a felony, then deadly force is justified under North Carolina law. But a caution is due on this particular aspect of deadly force in North Carolina. Additionally, North Carolina law justifies the use of deadly physical force to effectuate the arrest or prevent the escape from custody of an individual who is attempting to escape by means of a deadly weapon.